The American dream, for me at least, had always included a small workshop, a place to smell the sawdust, to turn raw lumber into something useful, something beautiful. My garage, however, had devolved into a chaotic mesa battlefield where my table saw fought for territory with lawnmowers, bicycles, and holiday decorations. I needed a shed. Not a flimsy metal box, but a proper, small outbuilding in my backyard where my passion for woodworking could have a home. Living in the meticulously planned community of Willow Creek, however, meant that even a simple dream like a shed had to pass through the gauntlet of our homeowners association and its fiercest guardian, Mrs. Albright. Mrs. Albright was the chairperson of the Architectural Review Committee, ARC, a position she wielded with the absolute authority of a monarch ruling a tiny, beige kingdom. She had an almost supernatural ability to detect a non-compliant fence post from 50 yards away and spoke of community harmony in the same reverent tones one might use for a religious text. Her own property was a sterile testament to her philosophy, a lawn so perfect it looked like astroturf, and shrubs pruned into such severe geometric shapes they seemed to be cowering in fear. I knew this would be an uphill battle, so I decided to become an expert. For weeks, I didn't touch a single piece of lumber. Instead, I studied. I downloaded the 200-page document of our HOA's covenants, conditions, and restrictions, CC, rupees, and read it like a legal scholar. I found Article 9, accessory structures, which stated that any outbuilding must be under 120 square feet, no taller than 10 feet at its peak, and its materials and color must match the primary residence. It also required formal submission and approval from the ARC. But I didn't stop there. I went to the city's municipal website and dug through the building codes. That's where I found my trump card. According to City Ordinance 14B, any freestanding structure under 120 square feet was considered a minor utility building and was explicitly exempt from requiring a city building permit. The city didn't care. This meant the HOA was the only gatekeeper. Armed with this knowledge, I prepared a submission packet for the ARC that was a work of art. I included professional-looking blueprints for a Tungsten footshed, 100 SQFT, well under the limit. I listed the exact siding and shingles to match my house. I included paint swatches of the same beige and white trim. I wrote a polite, detailed cover letter. I followed every rule to the letter, creating a proposal so compliant, so utterly inoffensive, that I thought even Mrs. Albright couldn't deny it. I was wrong. 3 weeks later, I received a thin envelope in the mail. The letter inside was brutally concise. Dear Mr. Harris, it began. The Architectural Review Committee has reviewed your application for an accessory structure. The application has been denied. That was it. No specific reason was given, just a vague final sentence. The proposed structure is deemed inconsistent with the aesthetic character of the Willow Creek community. Inconsistent? I had proposed to build what was essentially a miniature version of my own house. The denial was so subjective, it was meaningless. It was a power play, plain and simple. I requested a meeting with Mrs. Albright. We sat in the sterile, air-conditioned community clubhouse, a space as devoid of personality as she was. I calmly laid out my proposal again, pointing out how I'd met every single written requirement. The rules are guidelines, Mr. Harris, she said, her voice dripping with condescension. The committee's role is to interpret those guidelines to maintain a certain standard. A shed, no matter how well it matches, creates visual clutter. It sets a precedent. Before you know it, the neighborhood will be filled with these little shacks. It's not a shack, it's a high-quality structure. I countered, my frustration growing, and the bylaws specifically allow for them if they meet the criteria, which this does. The committee has made its decision, she said, a note of finality in her voice that told me the meeting was over. I walked home, my blood boiling. This wasn't about aesthetics, it was about control. She simply didn't want me to have a shed, so she had manufactured a reason to deny it. For days, I stewed. I could sue the HOA, but that would be a long, expensive, and ugly process. I could give up and let my garage continue its descent into chaos. Or there was a third option. I had followed their rules. My proposal was perfect. Their denial was arbitrary and capricious, and the city didn't require a permit. I decided I was going to build my shed. I was standing on solid legal ground, and I was willing to bet that the HOA was relying on homeowners being too intimidated to challenge a denial from their all-powerful ARC. The shed kit arrived on a flatbed truck a week later. It was a beautiful thing, all pre-cut lumber and high-quality hardware. As I began to lay the foundation, I could feel Mrs. Albright's eyes on me from across the street. I saw the flicker of her phone's camera lens. I ignored it and kept working, making sure my construction site was clean and contained entirely within my backyard. 2 days into the build, the official letter arrived via certified mail. It was from the HOA's law firm. It was a formal cease and desist order, demanding the immediate removal of the unapproved structure. It informed me that I was being fined $100 for every day the structure remained on my property, and that if it was not removed within 10 days, the HOA would place a lien on my house and pursue further legal action at my expense. This was the moment of truth. My heart hammered in my chest, but I folded the letter, put it in a file, and continued fastening the wall panels of my shed. The letter also mentioned my right to appeal the decision at the next monthly HOA board meeting, which was in 6 days. This was my chance. Not to ask for permission, but to state my case and challenge their authority to stop me. I spent those 6 days preparing for war. I created a thick 3-ring binder. Tab 1 contained my original perfect ARC submission. Tab 2 had the HOA's vague denial letter. Tab 3 held the threatening letter from their lawyer. Tab 4 was the centerpiece, a printout of the CC rupees with Article 9, Section 3 highlighted in bright yellow. And Tab 5 was my knockout punch, a printout from the city's official government website showing Ordinance 14B, stating in no uncertain terms that a building permit was not required. I made copies for every board member. The night of the meeting, the community clubhouse was tense. The 5 board members sat at a long table at the front. Mrs. Albright sat with them, not as a voting member, but as the head of the ARC, looking impossibly smug. About a dozen other homeowners were scattered in the audience, drawn by the scent of drama. When my name was called, I walked to the podium at the front, my binder in hand. "Good evening," I began, my voice steady. "My name is Tom Harris. I live at 124 Chestnut Drive. I am here to appeal the ARC's denial of my shed and the subsequent fines." I calmly and methodically walked them through my binder. I passed out the copies. As you can see from my submission, I said, the shed I am building meets every single requirement outlined in our governing documents. It is 100 square feet, under the 120 square foot limit. It is 9.5 feet tall, under the 10-foot limit. The colors and materials are an exact match to my home, as required. I held up the lawyer's letter. Despite this, my application was denied without any specific, rule-based reason, and I am now being threatened with fines and legal action for building a structure that is, by your own rules, perfectly allowable. Then I turned to the final tab. Most importantly, I said, my voice rising slightly with emphasis, I would like to draw the board's attention to the city's building code. I gave them a moment to find the page. As you can see, the city of Willow Creek does not require a permit for and has no regulatory interest in accessory structures under 120 square feet. This means the only governing body with any authority here is this one. I looked directly at the board president. The denial I received was not based on any written rule in our CC rupees. The law defines such an action as arbitrary and capricious. An HOA board cannot invent rules that don't exist or deny a project that meets all written criteria simply based on the personal taste of one committee. Ember. To do so is an overreach of authority and exposes the HOA to significant legal liability. A hush fell over the room. I had just, very politely, informed them that not only were they wrong, but that I could sue them and likely win. The board president cleared his throat. He looked at Mrs. Albright. "Janet," he said, "can you explain to the board the specific, written rule Mr. Harris's proposal violated?" Mrs. Albright's smug expression had vanished. She was completely blindsided. "Well, it's about the overall, the feeling, the aesthetic character," she stammered. "Is that feeling written in our bylaws?" another board member asked, an edge in his voice. She couldn't answer. Her entire basis for denial, her personal opinion, had been exposed as having no legal weight. The board members exchanged uneasy glances. They were business people, real estate agents, accountants. They understood liability. They went into a brief, whispered huddle. The president called for a vote. All in favor of overturning the ARC's decision and rescinding all fines related to case 124B? 4 hands went up immediately. The president added his. It was unanimous. I packed up my binder, gave the board a polite nod, and walked out of the clubhouse into the cool night air, feeling 10 feet tall. The next morning, a sheepish-looking handyman hired by the HOA came by to formally remove the violation notice that had been staked into my lawn. Mrs. Albright refused to make eye contact with me for a month. Her reign of absolute power had been publicly checked, and she clearly hadn't recovered. I finished my shed the following weekend. The final coat of beige paint went on. The white trim gleamed in the sun. It looked like it had always been there. It was perfect. And every time I step inside, I don't just feel the satisfaction of a project completed. I feel the quiet, profound victory of a homeowner who did his homework, stood his ground, and proved that even the most powerful HOA Karen is no match for the simple, undeniable power of the rules.